Hey everybody, it's Wednesday. Welcome to the Hang Up. I'm Matt Dillahunty. Let me keep this relatively short because there's a lot of stuff to do. I'm just going to tell you this so that you guys can be even more impressed that not only am I here, but we started on time. For those who, my stream is a little lag there. I'm just going to ignore it. So on Monday, we have to clean up for the rats that we raise as part of Epic Loot Exotics. And we discovered that the remaining 800 pounds of rat food that we had was moldy, and it ended up killing a few of the rats. So we couldn't replace it on Monday. Tuesday was the 4th of July, and that means that Wednesday, today, is when we could do it. So we loaded up all 800 pounds, got up at the crack of dawn, drove to Fort Worth, Texas, to return it to the supplier and get 16 new bags, then met up with Aron Ra and family for a moment, and then drove back, got here, cleaned out all of the remaining rat food from everywhere, put new rat food in. It's all good and wonderful. Found yet another dead rat because of it. Then I had to cut my hair, shave, take a shower, and hop back out here when we discovered that Arden didn't have an easy way to contact tonight's guest. So Andrew managed to get a link and get logged in while I was sitting here in nothing but my boxer shorts, something that we normally reserve only for the highest level of patrons. So, Andrew got a quick free show, but I have no idea. I don't know enough about many things. That's why one of the reasons why I bring in the guests that I do. I'm an obsessive learner, but when something's important, I try to make sure that I get people. And as longtime fans of this show will already know, when it comes to the Supreme Court and working on unfucking the courts, there is no better guest to have than tonight's guest. Please join me welcoming Andrew Seidel, who's going to tell us everything we need to know about the recent Supreme Court decisions, how bad it is, how bad it's going to be, what the hell we can do about it, and why I shouldn't just throw in the towel.
Thank you for having me on. And yes, I mean, I cannot recommend people enough to join that highest level on the Patreon because, yes, it was wonderful. I'm devastated to be back on talking about what we're going to talk about tonight, though. I mean, this was a barn burner of a Supreme Court term that ended on Friday. They gutted a huge swath of American law, really important precedents, just like they did last term. This is a court that is drunk on power right now. And if you were paying attention, 2 or 3 weeks out, like in mid-June, there were some decisions that weren't so bad. The court didn't kill the Voting Rights Act entirely, right? It had put the Voting Rights Act in a coma in several decisions over the last decade, but it let it live to kill it another day. The court upheld the Indian Child Welfare Act, which was a really important law and was passed to end the forced assimilation of Native Americans into white families. And it defended that against a challenge brought by white couples who were claiming that law was racist. It refused to adopt a truly insane, it's not even a theory. We can't call it a theory or a doctrine. It's marketing. It's the independent state legislature theory, which is really just an anti-democratic power grab. And every one of those decisions is correct and good, except the court never should have been hearing them in the first place. There was a writer, I think his name's David Mack, he said, Supreme Court rules puppies should not be drowned in narrow ruling. Right, like that's where we are. Like these are obvious decisions, and I think that's kind of the best way to think about it. But then that same court said we are going to drown kittens and baby koala bears and fuzzy little owlets, right? A bit like Noah's God, maybe in that respect. This is a court that it gutted LGBTQ rights in a case involving no LGBTQ people. They overturned debt forgiveness in a case where the lenders didn't want any part of and were generally okay with the debt forgiveness. They ended race-conscious admissions in higher education, which some people call affirmative action, in a case where at least some of those students who had initially challenged it recanted, i.e. they were in favor of affirmative action. These are judges. And That's how we're supposed to think of them. But really what they are is politicians. They're politicians who are drunk on their power, and they are doing devastating damage to people's lives, to their basic human rights. That's where we are right now. That's the term that we just went through.
Wow.
And you know what I didn't even touch on, Matt? The scandals, all the scandals. Anyway.
And so there's so much that I just don't understand and can't even begin to grok right now, because I was sitting around and there was a lot going on. I got animals dying, and who knows what else is going on. And when the first couple of decisions came out, I was sitting there going, wow, maybe after it taking out Roe, maybe we're going to get some decent rulings to kind of make up for it, which is a weird way to think about the court in the first place, to think that there's a bunch of justices there who are like, okay, we got what was, politically expedient, and now let's give them a little something so that they don't, complain too much. It's sad that anybody would even have any incentive at all to think about the courts like that. And yet I'm desperately looking for some sort of upside or high point. And then I got a message from you and I started looking at the other rulings that were coming out. Let me just say, we're going to probably have to go through a couple of these and get into the weeds on what people really need to know. But where is religious liberty now? Is it now an excuse to do whatever you want to whomever you want?
I mean, that is, I think, exactly where this court has been heading for a long time. I wrote American Crusade, How the Supreme Court is Weaponizing Religious Freedom. It came out right as this term was getting underway. And in that book, I wrote that the new guiding principle of this Supreme Court is not the Constitution or the law, but simply this: Christianity. And I think that has been proven true time and time and time again. And by the way, there's also data to back that up, which I go over in the book, and which has only been sort of re-emphasized both last term and this term. I do believe we are pretty much at the point where the First Amendment has become a weapon for conservative, heterosexual Christian men to essentially impose on everybody else.
So looking at what we did, or what we see now, when I go to the Supreme Court, opinions of the court for 2022, and looking at just what came out on the 29th and 30th, wait, did I miss something from 27th? So we got Moore v. Harper, Mallory v. Norfolk, Kahneman v. Colorado. None of those are in what we're talking about. We're starting with Students for Fair Admissions, right?
Yeah, I mean, we can talk about any of those other ones too. I mean, the big ones that I was watching this term, the biggest one that I was watching was the 303 Creative versus Elenis case. That's because I specialize, obviously, in the intersection of religion and the law, more specifically keeping those two things apart. And that was a big case in that respect, even though it was based on First Amendment free speech. But yeah, there's the Students for Fair Admissions case. That's actually a pair of cases. Students for Fair Admissions sued both Harvard and the University of North Carolina, challenging their affirmative actions. There was Moore versus Harper, which is that independent state legislature doctrine case. I mean, that really is, I think, one of the best examples of the absurdity of the time that we are in right now. That really is the SCOTUS
getting it right on something we should
be drowned.
Yeah, that basically in that case, they're getting it right on something they should have never been before them anyway. It's like they're going to put a couple of T-balls up. It's like they specifically took some that weren't going to be particularly controversial as window dressing for the others.
And there are actually some dark signs in the Moore versus Harper case. The court didn't do the what we all feared, but it is something of a power grab by John Roberts and the Supreme Court itself. back in 2000, the Bush versus Gore case was like one of these cases where we are all like, this should never happen again. It has never been cited by the Supreme Court positively or really at all since. And in a way, I think you could make an argument that one of the things they were doing was sort of confirming the course of action that they took in Bush versus Gore and saying, we might do this again. They're not letting state Supreme Courts necessarily be totally neutered, but the Supreme Court itself is going to be likely wading into these fights again in the future, a la Bush versus Gore. So it's not necessarily a soothing opinion. They just didn't they didn't drown the puppies, but they're like, we might drown them later, kind of thing.
So
Oh,
go ahead. I was going to say let's go ahead and jump forward to 303 Creative, because as that's the one you focus on the most, and it's the one that strikes the hardest at religious liberty. This reminds me, as a layperson, of the cake decorating debacle from a few years ago. And essentially, you've got an individual from the decision on the 30th. Lori Smith wants to expand her graphic design business, 303 Creative LLC, to include services for couples seeking wedding websites. But Ms. Smith worries that Colorado will use the Colorado Anti-Discrimination Act to compel her, in violation of the First Amendment, to create websites celebrating marriages she does not endorse. To clarify her rights, Ms. Smith filed a lawsuit seeking an injunction to prevent the state from forcing her to create websites celebrating marriages that defy her belief that marriage should be reserved to unions between one man and one woman. So, as the layperson here, hey, I'd like to do websites, but I don't want to do websites for gay couples. And normally, we've got protected classes, and if you're going to run a business that's open to the public, there's, if I create a website for you, it's absurd for any sane person to think that I am in any way endorsing the content of that website through the creation, or that I am in any way speaking on your behalf any more than if I hired a Java developer to come in to write code for my shitty Jesus first person shooter game. And nobody would expect that Java developer would be saying, yep, I support Jesus. And yet go ahead and run us through the case, because you're going to do it better than I could ever do.
Yeah. I mean, there's so much to talk about here. And I mean, just as an initial matter too, like when I designed my own website, my website designer, James, was like, you need to send me everything you want to say. He's like, I'll do it and I'll copy and paste it over, but you're writing the actual copy. But the top line here is that the Supreme Court gutted our system of civil rights laws. And these are the system of civil rights laws that have done so much to actually get us to that aspiration that we have as a nation, that promise of equality. And it did so in a case that it absolutely never, ever, ever should have been hearing in the first place. And you are right to liken this to the Masterpiece Cake Shop case from 5 years ago, the gay wedding cake case. It's the exact same case, only worse. In both cases, a business sought to discriminate against LGBTQ people. Now, the older case, a bakery actually did the discriminating. And it was, so one difference is bakery versus website business, but I'll touch on a few others in a second. But the same Christian nationalist legal outfit, the Alliance Defending Freedom, was behind both cases. The same ADF lawyer attacked the same civil rights statute with the same First Amendment arguments in both cases. In the latest one, the 303 case, they focused on free speech instead of freedom of religion. The court did. But there's really two big differences between the case. The first is that the court is different. Okay, so in 5 years, Brett Kavanaugh replaced Anthony Kennedy on the court, and Amy Coney Barrett replaced Ruth Bader Ginsburg. Now, one of the hallmarks of American justice is that a change in personnel is not on the Supreme Court is not supposed to change your rights as a citizen or an individual. That's obviously a myth, a lie. That is not true, because this change in court personnel changed people's rights. And the second big difference is that in the Masterpiece Cake Shop case, a couple was discriminated against, right? I mean, that Charlie Craig and Dave Mullins were refused service by this bakery. And in this 303 creative case, nothing happened. Nothing happened
and worse,
at all. Yeah,
My
we'll get. Yeah,
understanding.
well,
Okay,
yeah,
go ahead.
absolutely. Well, give me 1 second. I mean, but
Yeah.
even before that, Matt, the entire case is artificial and hypothetical and manufactured, or as I wrote in my op-ed, to use the legal term of art, it's bullshit, right? I mean, this wedding designer business did not design wedding websites. It designed websites for churches and Republican politicians, bad ones, as far as I could tell. Had never been asked before the case was filed. Had not had the civil rights statute enforced against it. No action was taken against this entity whatsoever, and still they brought this challenge. Now you can do that in some really, really, really rare instances, but not here, where a law has been on the books for 40 years, and this kind of challenge has already been upheld repeatedly by the Supreme Court. There's a case, one of my favorite cases in 1968, where the Supreme Court actually laughed off these First Amendment free speech and religious freedom arguments as, quote, patently frivolous in a footnote. And that's what the court turned its back on today. But definitely, please tell folks about the extra fabricated aspect of this.
So not only was now I could see, just setting aside legal stuff, just armchair, hey, I'm starting a business. I could see wanting to make sure that you're starting a business, that you're going to be able to operate the way you want. And if you have concerns that the law is going to, hinder your ability to do business the way you want, before you go and put a ton of investment into it, it may be worth it to see what, the courts have to say, or maybe hire a lawyer to investigate or whatever else. That makes sense to me. But in this case, there was no website. There was no request for a website. And at some point, evidently, there was a claim that some individual had requested a website for a same-sex wedding. And then shortly before this decision came out, but after it had been decided, I guess just before they published it, the named individual came out and said, I never requested a website. I never requested, I could make my own website. I never requested a website for a gay wedding. And I'm a straight man who's been married for 15 years. Now, how is it that a case where there's only hypothetical clients cites one non-hypothetical client that I know of? There may have been another one, but at least this one non-hypothetical client that turns out to be an absolute fraud top to bottom, and yet this makes it through the court.
Yeah. I mean, the answer is the court wants to take these cases, which is, again, something I talk about pretty extensively in American Crusade. That request came in the day after the lawsuit was filed, right? And it was for Stuart and Mike, and never responded to that request. It was actually very vague. It said, we might want some design work for our wedding invitations. I believe it was invitations and maybe place cards or something like that. And then they said something like, we might even stretch to a website, right? Like really, really vague. Not at all clear that that's what they're looking for, and not part of the original complaint, because it happened the day after the initial lawsuit was filed. Right. So from top to bottom, this case is artificial. It's hypothetical. I had a viral Twitter thread the other day talking about some of the behind the scenes nonsense that we know happened here, because this story about this fabricated request kind of blew up in ADF's face, rightfully so. And people are looking and like, how can something like this happen? And, they're pointing out that Aron Hawley, who is Senator Josh Hawley of Missouri's wife, is on the Alliance Defending Freedom's legal staff. She's a lawyer there, and pointing out some of these connections. And there's so much here, it's ridiculous. Not only is she on the staff of ADF, she argued the mifepristone case that's been going through Texas, which the judge there is a judge out of another Christian nationalist legal outfit, First Liberty Institute. Hawley taught, Senator Hawley, Josh Hawley, taught at ADF's fellowship program for a number of years, cashing in on that, alongside Supreme Court Justice Amy Coney Barrett, who taught at that fellowship program up until 2016. Josh Hawley and his wife met while they were both clerks for Chief Justice John Roberts. Right? I mean, the layers upon layers upon layers here of this this onion. I've written a lot, especially in American Crusade, about how this begins to stink like collusion. And I really do think that's what you're seeing here. You're seeing these Christian nationalist organizations, this sort of shadow network of power that is not only putting justices on the bench with the help of Leonard Leo, who's certainly a part of this, but then creating and fabricating these cases that they can bring before their former colleagues to change the law in this massive, massive way. And that's what we saw happen in the 303 creative case.
So here's something I'm confused about. It may just be because I didn't follow this closely enough. So the plaintiff is Lori Smith from 303 Creative.
No, there you go. Yeah. I think this is an important distinction, and I'll do this throughout Lori Smith is not the plaintiff in this case. 303 Creative LLC, which is a business. LLC stands for Limited Liability Company. You can look her up on the Colorado Secretary of State website. 303 Creative Limited Liability Company is the plaintiff here. It is a business, a for-profit business that is protected under the laws of the state of Colorado and is a place of public accommodation under Colorado law. She opened her business to the public, so this is a place of public accommodation. And this has absolutely nothing to do with Lori Smith. And if we talked about her, or if we talked about her less and about the business more, I think that would make a big difference here. I'll leave it there. Yeah.
But the defendant is listed as Aubrey Elenis. If 303 Creative is suing, I thought when I first read about this, it was essentially the state, because it was Colorado's laws that she had concerns about. Who's Aubrey Elenis, and who was defending this case that allowed it to get all the way through the Supreme Court with what appears to be just a fraudulent claim about a potential client? And
yeah, so it's a really good question that I think a lot of people are going to be looking into. So Aubrey Elenis is one of the people, I believe she's the chair of the Colorado Civil Rights Commission. The Colorado Civil Rights Commission is charged with enforcing the Colorado Anti-Discrimination Act. And that is Colorado's central civil rights law. It's the public accommodations law. So it's pretty typical that that's who you would sue. Colorado's attorney general at the time this case started was a Republican who, if you go read Gorsuch's opinion in this case, he extensively relies on the stipulated facts, how the parties agreed. And a lot of this agreement came under the auspices of this Republican attorney general in the state of Colorado, which I would not be surprised if we found out some of those ties existed there, those layers that we were talking about. I'm sure somebody's already digging into that right now. I know I was the other day. Point being, the defendant agreed to a lot of stuff that maybe it shouldn't have. Strategically, not necessarily the best idea. But if the court is going on 6 decades of law and precedent, those stipulated facts wouldn't have made any difference. But because this is a court that wants to take these cases so that it can advance Christian nationalism and the rights of conservative white Christians at the expense of everybody else, you ran into this basically buzzsaw in this case.
Wow. Okay. So basically, Elenis et al. Is just the Colorado Civil Rights Division, whatever. So it's not, we don't have an individual, and we don't have, it's not like they're suing the governor or anything. Cause I don't know who you see. This is so weird because you were talking about how this case shouldn't even be before them at all. So I'm starting a business. And I want to make sure I sell snakes, and I want to make sure that the state of Texas doesn't do what the state of Florida is doing, which is running around killing people's snakes and trying to whitelist what pets you can have instead of blacklisting problems, and just doing everything they can to minimize rights. And so before I invest a bunch into this, I go out, and normally I just get a lawyer to tell me what my limitations are or aren't, so that I can make an educated decision. But in this case, she decided to sue. And the only way that makes sense is if this Christian Dominionist law firm went out and looked for a plaintiff,
100%.
or manufactured one.
100%. ADF manufactured this case. So Lori Smith did not start this case. I mean, ADF has been taking cases like this around the country for about the last 8, maybe 10 years. You've actually heard about some of the other ones probably without even realizing it. There's other bakery cases, there's florist cases, there's photographer case out of New Mexico. ADF has been trying to use this strategy to gut civil rights laws for the last decade. And they kicked it into overdrive really after Obergefell. In fact, maybe we can date the strategy to Obergefell, the marriage equality case.
Right.
I mean, this is what they have been trying to do. ADF is the one who orchestrated this case. I mean, you already mentioned the gay wedding cake case out of Colorado. This is them getting their second bite at the apple, right? They're like, okay, we didn't get exactly what we wanted that time, and part of the problem was we had this really sympathetic gay couple, Charlie Craig and Dave Mullins, who I'm proud to call friends, who were the face of this bigot's discrimination. Like, how can we get around that? I know, we'll create this case where nothing has happened, and we'll see if we can get the court to take it. We'll see if we can get them to take this pre-enforcement challenge so that there's no victim of discrimination here. And then when we paint the bigot as the victim, there's nobody to counteract that narrative, right? And if you remember the Masterpiece Cake Shop case, this is one of the more remarkable things Christian nationalists have been able to do. That case was about a bigoted business discriminating against a powerless minority. That is what it was fundamentally about, a protected minority group. That is what happened. Discrimination, pure and simple. And by the time it got to the Supreme Court, ADF had pumped so much money into their media machine and into whitewashing this case that it became about the government, the big bad government, coming along and persecuting this poor Christian artist who just wanted to practice his craft, right? They completely flipped that narrative. And the only reason that it didn't catch on entirely is because there was this couple who were like, oh, hello, I mean, what about us? And you didn't have any of that in this case. There was nobody to stand up for the LGBTQ community to put a face on the cost of that bigotry. And that's why one of the reasons they were so successful here. Plus the court personnel.
I haven't read the entirety of either Gorsuch's majority opinion or Sotomayor's dissent or anything like that. But I did read the end of Gorsuch's thing. And so it says, in this case, Colorado seeks to force an individual to speak in a way that aligns with its views, but defy her conscience about a matter of major significance. Now that sentence, which is the opening of the closing of his majority opinion, how is Colorado forcing an individual to speak in a way? And what makes this, because this sentence is awful. In this case, Colorado seeks to force an individual to speak in a way in ways that align with its views, the state's view, but defy her conscience about a matter of major significance. How is this the state's view? How is saying, so they're not forcing her to say shit. And
Correct.
Even if they were forcing her to publish what someone else had done or develop a place for somebody else to publish their own thoughts, it's not the state's view. This thing is written as if anybody gets any same-sex couple gets married in Colorado, the mere announcement of their marriage is an endorsed representation of the state's view on marriage.
Yeah, I mean, there's a lot that's so wrong in Gorsuch's opinion, and you've put your finger on one of the things. It's really interesting. I was talking with another lawyer about this earlier today. This opinion really does take advantage of the fact that most Americans don't understand basic civil rights laws. And I think most media too, and some of the reporting that you're seeing coming out of this case makes that pretty clear. The Colorado law does not force anybody to say anything. She is not required to build wedding websites. and then make statements on them. All it is if she decides to use her business as a place of public accommodation and open it up in the marketplace and get all of the benefits that come with that, she has to open it up equally, right? They're not forcing her to say particular things. The statute targets conduct, not speech, for regulation, right? It is the act of discrimination that is being targeted. And the act of discrimination has never been protected expression under our First Amendment until this opinion.
What's weird, every sentence I read further, I sometimes wish that I was a lawyer and that you and I could work together on this stuff, because I just jones on this stuff. But looking at what's written here at the end of this, tolerance, not coercion, is our nation's answer. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed. But nothing in the law, even if the law required her to create a website for gay couples, none of that denies her the right to free thought and free speech. She could create a website talking about how much she, as a Christian, is opposed to gay marriage. She has that right. No one's forcing. This ruling acts as if we're denying her by saying, if you're going to make a website, you need to be able to make it for, whoever's there. And she claimed, or 303 Creative, I shouldn't keep doing she. 303 Creative's position was that they're happy to work with people of all genders and sexualities, but they're not going to create a website that seems to endorse or present them as endorsing gay marriage. And yet there's nothing in Colorado's law that denies them the right to say, I'm opposed to gay marriage. Jesus doesn't like it. I don't like it. I'm opposed to it. I'll keep making these websites because they're paying me and because the state says I have to offer this opportunity to everybody. But let me be clear, I'm opposed to gay marriage. There's nothing preventing 303 Creative from doing that. And yet the final lines of this opinion read as if that's exactly what they're preventing. 303 Creative is being prevented. It literally says, Colorado seeks to deny that promise, the promise being where all persons are free to think and speak as they wish, not as the government demands.
Exactly. I mean, and I do think you would make a good lawyer. It is frustrating, though, when you know you have the right side of the argument and the facts and the law are on your side, and turns out it doesn't fucking matter, and that's this Supreme Court.
That's so wild.
But it really is. I mean, the idea that all persons are free to think and speak as they wish is, of course, absolutely true, and has been true the entire time we have had this system of civil rights laws in place for the last 60 years. The courts said that many, many times. It's almost a non sequitur, right? I mean, but when you open a business and that business is also a place of public accommodation and you are taking advantage of all of the benefits of the marketplace, you have to obey some of the strictures as well. And one of those is that you serve people equally, especially those that are part of a protected class, right? Lori Smith is free to be a bigot all she wants. 303 Creative has to follow the civil rights laws, or at least that used to be the rule.
What does this do to protected classes in general? Because, my limited understanding is that we're looking at, public accommodation, protected classes, and who you can't discriminate against. Like if I have a business, for example, people in MAGA hats are not a protected class.
Correct.
I may still not be able to refuse service to them if I'm running a business that is open to the public. I may not be able to say, nope, I'm not going to serve you while you're wearing your red Make America Great hat again. But I might. Who knows? I'm not going to push it. I'm not a lawyer. I don't care. But now, I care, but it's not relevant to this. Somebody posted a meme that says, wait until they tell you that they're not going to make your bar mitzvah invitations. That seems to me, because that would be even more, just as much, if not more compelling of violating someone's religious beliefs. If I'm anti-Jew, if I'm whatever, this puts me in a position where there's nothing to stop me from just saying, nope, I'm not going to make any Jewish invitations. I'm not going to make any Scientologist invitations. I'm not going to do any Muslim invitations. And so religion could be out as a protected class, because even though this one was geared towards same-sex marriage and homosexuals being one of the protected classes, or sexuality and gender being among them, if the grounds for denying this was that just by participating, I was essentially, or 303 Creative was being compelled to speak the state's position in violation of their own, none of which is true. And so how do you not get to use this as precedent to just say, you know what? I mean, apart from showing that it was a sincere religious belief, which I think is probably the biggest, it's not like I could just say, I'm no longer going to serve people in MAGA hats, and that's my sincere religious belief, because I don't think the court would let me just make up a sincere religious belief, no matter how sincere I say it was. The language of a sincerely held religious belief tends to coincide almost entirely with long-standing, particularly bigoted views that the court also shares.
That coincidence does seem to exist, but it's even, the decision is actually far worse than that. I mean, this is one of the things that I think is most terrifying about this decision is I do not read in that opinion a limiting principle. For instance, the idea that this was the business owner's sincere religious belief doesn't actually matter in the end analysis of Gorsuch's opinion. It is because this is, as he put it, a pure free speech case. Yes, that's why she doesn't want to speak it, but the fact that she doesn't want to speak in that way is all that matters. So you don't even need the religious element to actually do the discriminating here. But there's two, I think, even more alarming aspects that you touched on. And the first is that it is not possible to draw a logical or consistent line between discrimination against one protected class, like race, and another, like sexual orientation. Because once religiously motivated or otherwise discrimination is permitted, the line has already been drawn in the wrong place, right? Instead of drawing the line between night and day, we're drawing the line between these shades of benighted bigotry. Okay, so I do not see any way that you can read this opinion and think, okay, this at least does not allow discrimination against minority religions, or okay, it's awful that this allows discrimination against LGBTQ people, but BIPOC are safe, right? Racial discrimination is coming in the wake of this. Religious discrimination is coming in the wake of this. And I promise you it's coming. One of the things that we know is that when decisions like this come down, the bigots are emboldened. Not only are the bigots on the ground, any bigot who owns a business going to be emboldened, but ADF and the other Christian nationalist organizations out there are going to file case after case after case, working to expand this decision to everyone, from photographers to sandwich artists, right? And there was a moment, and I write about all of this in American Crusade, but after the gay wedding cake case, which we've talked about a lot, there were, even when they didn't win that case, when bigots didn't get the weapon that they wanted, they were still pushing the limits of discrimination. And we still saw, there was a study done, we saw discrimination spike all over Colorado after that case, even though they didn't win. And there was this one famous moment that it hit for a day, it went viral, where a wedding venue turned away an interracial couple, saying, we don't do gay weddings or mixed race because of our Christian race. I mean, our Christian belief. Yeah. Right? And that, we already saw. It's exactly what our civil rights laws are supposed to protect against, and what they have done successfully for 6 decades. And that is what the Supreme Court gutted.
We talked about this when we talked about Roe. Them in the decision on Roe, just listing everything that was left. I want to touch on this just because I know people are going to ask questions, and then we'll get to calls. I know we're a little slow getting to calls today. Appreciate everybody's patience. There's a whole bunch more that we could talk about, and we probably will, and many people will talk about that decision for a long time. I want to touch on Students for Fair Admission versus president and fellows of Harvard College, because while this doesn't hit the same religious freedom or First Amendment rights, this seems to destroy affirmative action. And while I'll be the first to acknowledge that there are inevitably going to be problems with quotas and affirmative action, no matter how you try and implement them, there's a grand irony here that several of the people sitting on the court right now are beneficiaries of affirmative action. And then I saw a great meme where it's like Thomas and Barrett benefited from affirmative action and then pulled the ladder up behind them by gutting it for everybody else. What's your take on Students for Fair Admission?
So first of all, affirmative action does not work with quotas. That quotas have never been allowed as part of affirmative action. There's a number of cases that have challenged affirmative action. Backey in 1978 and Grutter versus Bollinger, which I think was 2003, I want to say. Basically have all said no quotas. But it's okay to consider race as one factor in this sort of holistic assessment, I believe was the term, of applicants. And look, yes, in an ideal world, race would not matter and we should strive for that. But that is not where we are. And even if we get there to a world where race doesn't matter, it would not erase the centuries of discrimination and oppression. My friend Tori Douglas, who runs a program called White Homework, she wrote that to say, I don't see race in a country where race is the metric for humanity is to functionally state, I choose not to see injustice. In other words, to declare now that we are all equal does nothing to arrive at equity or equality or better yet, justice, right? That requires more. And I by no means am an expert here. There are a lot of people who are better equipped to talk about this. I try to do more listening and learning in conversations in spaces like this, but to the extent that you're asking, does this decision gut affirmative action? I think it really does. Roberts does one of his... this is actually like one of his MOs. This is one of the things he loves to do, is he loves to essentially effectively kill an area of the law and then hasten to say that he's not overturning the precedent, or not, that things are not all entirely dead. But it does appear like that's what he did. I mean, there are spaces where even in the opinion, it's clear that, for instance, Roberts says we're not going to apply this to the military academies. Because diversity may be really important in the military. And if people don't understand how useful and how helpful and how important affirmative action is, there are some brilliant briefs that were written to the Supreme Court from just about every possible area of our society that you can imagine, from medical professionals who are basically pointing out that if you overturn affirmative action, you are going to kill people of color in the United States. That is going to happen because of the dynamics of our medical system. To businesses and huge corporations who are pointing out all the benefits of this. I mean, essentially nobody wanted this except for, I'll just, one tiny little rant. This is also the project of this one conservative activist, a guy named Blum, who's been trying to get affirmative action overturned for a number of years and who just brought case after case after case, like ADF, just tweaking it every time until he got to the place where the court personnel had shifted enough that despite all of the cases upholding affirmative action, we now are here and they're just upending it.
When you said that, was it Gorsuch or whoever it was saying that, hey, we weren't going to enforce this over military academies?
Roberts.
Yeah, and did you say military academies or military admissions?
It was a school case. I'd have to go back and look at the actual limiting language. And I didn't mention the second place they limited it, but Justice Jackson is so good. So good. And she asked a really brilliant hypothetical during argument about basically a student who wanted to get into North Carolina, who wrote about how they were a legacy and their family had been going to North Carolina for 5 generations. And then a student whose family was enslaved and couldn't write that. Could they not write I wasn't able to go here for generations because my family was enslaved, and this was not your school was not open to people who looked like me for a long time. And that on the strength of that hypothetical, she actually forced Roberts to do this strange carve out in the opinion for maybe students can write about their personal experience regarding race in an essay, and maybe the schools can take it into account in that way, but not if it's very bizarre. And it's an interesting logical contradiction in Roberts's opinion. Both of those exceptions are.
It's so strange because while I don't have stats on military academies, the carve out for something like that, first of all, on military admission, it's one of the places where I would hazard a guess, since I served for 8.5 years and got to watch this stuff firsthand. I don't think that we're having a diversity problem with respect to minorities in general military admissions, because the military recruiters already prey on lower class individuals, people who are impoverished. This is your way. This is your way to potentially get a college degree. This is your way to get respect and legitimacy and all this stuff. And so you don't need that sort of admission. I don't know if that applies as well to military universities, so I won't speak to that. But it just seems strange. The second you said it, I just had that reaction of, hang on, we're doing a carve out for the military. That should tell you quite a lot about what's going on here in reality. This is not, nobody thinks equality has been achieved. It's just they've stopped caring about whether or not it's achieved. It's, we've dealt with this long enough. We've bent over and kowtowed and offered opportunities, and maybe it's helped and maybe it hasn't, but damn it, let's see if it's actually helped. Because if we're actually post-racial, we could be the Supreme Court that demonstrates we're post-racial. And that's why it's almost like what they're hoping for. I'm going to take calls here in just a minute to get to the people who are waiting. I want to mention somebody else, because you talked about someone who talked about not being able to see race. And I have a friend or a friendly acquaintance, Anthony Penn, who's, Tony, he's at Rice. And Tony was the first guy that I ever heard say that. Anthony Penn, Dr. Anthony Penn, Professor Anthony Penn, he's just amazing. At one of the various secular conventions we were both at, gave a talk about, please stop saying you don't see color. And it was a brilliant talk. It was very useful. It got me and several other people to realize that what we thought we were saying, and I wasn't too keen on saying this, but I'm sure I had said something similar or given the same impression. Well, the message we thought we were conveying isn't what was actually there. Even if you can't see at all, you will still be able to see, metaphorically, color. You'll be able to hear it. You'll be able to feel it. You'll be able to enter, as you watch the disparity, the data remain the same, whether or not you have eyesight or color vision. And he went into a great dissertation on how people need to stop doing this, because while it may not be as bad as the explicit racism, it endorses the sort of implicit racism. It endorses the racism of lowered expectations and all of the other problems in there that are exacerbating to pretend like we're post-racial when we're not. And it was like, one of the things is it also denies the achievements, because when you have people of color who have achieved despite not starting on the same footing as somebody else who perhaps had more advantages. And by the way, the privilege and advantages, that's not just driven down a particular line. It's not like all white people have an advantage and all people of color have a disadvantage. We're talking about norms and averages. And, if we're going to start a race, where does everybody start? And if I get to start on the 40-yard line and you start on the 10-yard line and somebody else starts at the 20-yard line, we don't have an equivalent position there. And when you say that you don't see color, that can also result in you denying the achievements of the people who started at the 0-yard line while you started at the 40-yard line. And you got up there, you might have won by by 5 yards, and you're like, hey, I don't see race at all. Well, then you don't see that I was fucked out of a 35-yard head start that you had. And so, yeah, it's problematic at least. We have a bunch of calls, and we're going to start with Mary in Florida. We have lots of calls and lots of stuff. If you have questions for Andrew, I'm going to put you through so that you can ask your questions, Andrew. Please, let's not do long dissertations and multiple layered questions, but Mary gets to start off. Pronouns she, her, has a question about Supreme Court ruling and LGBTQ plus women's rights. So welcome, Mary.
Okay.
Hi, Mary.
Thank you. Hi, Matt. I've been waiting for you to have Andrew on because I wrote down a list of questions.
Me too.
I'll be brief. I've crossed off some that you've already answered in your presentation, so I'm good there. I just saw a little clip today. I don't know if it's true or not, but is it possible that Alito and Thomas are talking about retiring to possibly avoid impeachment? Have you heard anything about that?
I've not heard anything about that. I do not think that's true for a couple of reasons. The first is that these are two guys who have been desperate to be able to do what they have been doing for the last 2 years. I mean, imagine two people who are just chomping at the bit so badly to decide cases the way they've been deciding them. I mean, they've been desperate to be able to recklessly exercise their power the way they are now. I mean, it's like they have finally arrived at the fucking disco. They are not about to turn around and leave, even under the threat of impeachment, which is, I think, the second reason I'm very skeptical of this is the threat of an impeachment is just not a threat at all, as we have seen repeatedly now. You know, the impeachment is meant to be this great check on the other branches, but we know it is not the case any longer. Think of the political capital that the Republicans spent to put Gorsuch and Kavanaugh and Barrett on the bench, right? To get that 6-3 conservative supermajority. They changed the size of the Supreme Court for more than a year, for more than 400 days to get Gorsuch on the bench. And then they changed it back when they were able to do so. They overrode credible allegations of sexual assault for Brett Kavanaugh. Brett Kavanaugh threw a temper tantrum and promised political retribution in his Senate hearing and still got confirmed. I mean, you all saw what happened with Amy Coney Barrett. I mean, one of the just in absurd, shotgunned onto the Supreme Court. Anybody who accepted that position showed their unfitness for the position in the first place, and accepted that nomination showed their unfitness for the position in the first place, as I wrote at the time. The idea that you would get any defections from the Republican Party to get one of their stalwarts off the bench is just not, it makes no political sense. They're not going to all of a sudden change their minds about what they want out of the Supreme Court and give up a vote and let Biden have a chance to appoint somebody else. Just zero chance that will happen. If we have a Republican president and a Republican Senate, you might see some strategic retirements. But even then, I still think the first reason that I gave, we're unlikely to see some of that.
But even though they've broken the law on accepting these extravagant, billionaire trips and vacations, haven't they done impeachable things? But is the House of Representatives able to block that?
Let's assume they have. My point is that it doesn't matter right now, because impeachment is not the check that we thought it was. I mean, Trump absolutely did impeachable things, right? I mean, violent insurrection, right? And they still got him off. And the entire Trump presidency for them was about securing the Supreme Court. The idea that they're going to turn their back on that just doesn't wash for me. I think the scandals that are rocking the court with these right-wing billionaires who fly them around the world on private jets, who sail them around the world on super yachts, who host them at their cushy resorts, who pay for their family members to go to college, who pay for their mother's houses. Right? I mean, I think I think there are certainly some impeachable offenses in there. And I think we've probably not heard the last of these. Matt, I even feel like when the first one of these broke, when Operation Higher Court broke, I might have been on here saying how we're going to hear a lot more about this. So I mean, I think more of these stories are coming too. But really what they are at their most basic level right now in terms of violations are disclosure problems. And that's because there's not a real ethics code that is binding any of the Supreme Court justices. I do not think you are going to... I put the chances of any of these Supreme Court justices being impeached at 0.
Man,
and even if they were to be
bumming me
impeached...
out.
I know. Even if they were to be impeached in the House, the Senate removing them from office is also a 0. So, yeah.
Well, what's keeping Biden from adding a few more justices and packing the court a little bit? What's he waiting on?
Us. The numbers are not in favor of doing that. There has not been enough pressure from we the people on politicians, especially Biden and the Democrats, to make that happen. I absolutely think that is the solution. I think that is the route that we have to go. But it is incumbent on us to scream that from the mountaintops, to make that our central issue in every election, is not packing the court, because the court has already been packed, right? That has already happened. The Supreme Court was packed. There was a deliberate attempt to capture the Supreme Court that was successful. And now they are reaping the benefits of that capture, of that court packing. The question is, what are we going to do about it? And the number one thing I think we need to do is start framing it like that. This court is already packed. What are we going to do about it? The court is captured. What are we going to do about it? And the answer to that cannot be nothing. And if the answer is nothing from a candidate that is asking for your vote, I think you should tell them to pound sand.
So, okay, by packing, is that, does that term mean put in? I just mean extend the number. Yes. Right.
Yeah. First of all, Mary, I love the birds in the background. It's actually like soothing me a little bit. I'm a huge bird nerd. But yes, that is what I mean as, I think that is the solution to what has happened to the packing of the court, is expanding the court. Now you hear a lot of expand the court. How many do we do? The number that is floated around most often is 4. I think that's fine. I'd be happy with 6. I'd be happy with 10. I'd be happy with 40. I do not think we can allow billionaires to capture our institution and get away with it. I think something has to change. You cannot reward that kind of attempt to capture one branch of our government by doing nothing about it. And if that means expanding the court by a whole lot, I think that's absolutely worth doing. And now the common thing that I hear back is, well, what if then the Republicans go ahead and expand it back to get their majority? Well, again, first of all, they already changed the size of the Supreme Court and packed it when it suited them. That has already happened. What we're talking about doing is a corrective for that. Second of all, who cares? Let that happen. I mean, the more justices that are on that court, the harder it is to buy influence with that body. Right now, there are only 9 on that court. That is an easy body to capture, as we've seen. The more there are, the harder it is to capture. The less power any individual one of them has. I'm all for it. Let's have 101 justices on there for all I care.
All right, and I'm really watching what Jack Smith is doing. He's wonderful, but I'm wondering if you've, like the whole GOP, accusing, weaponizing the DOJ and all that crap. Do you think that when January 6th, Jack Smith brings down indictments for people, do you think it's going to include some Republican members who were in on the fake elector stuff too? And that's why they're just kind of freaking out and having all these hearings on all this stuff. I mean, I would love to see Jim Jordan and Ron Johnson and a ton of them get indicted for their role in January 6th.
I don't know if
that's
that's. I don't know
in
if
your
it was.
crystal ball.
I don't know if it was if that's why they were doing it. If it was preemptive, if anything, I think it was preemptive to destroy the credibility of the inquiry with their base, right? To discredit any proceeding with the MAGA folks. I mean, I think that's what it was really meant to do. I don't think they could have predicted what Jack Smith was going to do. I don't know whether that will happen. I think there are probably a few who are pretty intimately involved with some of the seedier and shadowier aspects of January 6th. So we'll certainly see.
And people are flipping and talking, so I think they're really nervous. But also,
I gotta wrap it up. I gotta wrap it up, Mary. We got extra lines open, and there's a whole bunch of people waiting. So I appreciate your time.
Is there a chance Trump will go to prison? Tell me yes.
There's a chance. I don't know how likely it is, but more than the justices getting impeached.
Way to just respectfully ignore my request to stop and get your question in anyway.
I'm sorry, Matt. Love you, Matt. Mary. Thank you.
It's all right. We love Mary, and it's a good question. It's just that maybe that's a question somebody who's been on hold was getting ready to ask. Every time somebody asks me, and I get it. Not a lawyer. No real expertise here. I'll be shocked if Trump ever serves a day of prison anywhere for anything, despite the fact that on the face of things, looking at this, I don't know. I mean, it's going to be shocking. It would be so easy. Like if it was me, I'd be fucked. I'd be in prison already.
He's a rich white guy. He's also got Secret Service protection. There's issues.
Yeah, somebody mentioned that because he's required to have Secret Service issues, we'd have to lock the Secret Service up too. So is that a real thing? Can't we just say, you know what? No, you don't get any Secret Service stuff anymore.
If you don't elect criminals, this wouldn't be a problem.
True. All right. Getting on. We actually have a theist caller. And since theists always have priority, it's Arthur in New York. Pronouns are he, her. Has a question about modern day outlook on religion and fundamentalist doctrine impacting the court. So welcome, Arthur. Andrew is here to answer your question, and I'm here to referee.
Hi, Arthur.
Yes, sir. Thank you. Yeah, hi, Mr. Seidel, and thank you, Matt, for taking my call. It's an honor to be on your show. Thank you, gentlemen. My question is about which doctrines Andrew or Mr. Andrew Seidel and Matthew do you think shape both the modern political movement, maybe more on the right fundamentalist wing, because since that seems to be the wing that is winning out at the moment, and where do our hindrances lie as liberals? I'm a liberal theist, so I think women's rights, gay rights, LGBTQ plus, all that stuff. So where do our hindrances lie in coming together as a team here?
I'm not entirely clear about the second part of your question, but I'm going to take a stab at that first. I in a fight against authoritarianism or fascism or white Christian nationalism, which are all very intimately related and sometimes seem to be the same thing, I think that shared values matter more than shared beliefs. I've been doing a lot of work over the past few years as we have seen Christian nationalism gain more power, gain more political power, gain more judicial power. I've been doing a lot of work with liberal Christians whose values overlap with mine. And the truth of the matter is, I'm at the point where I'd rather sit down and talk about racial justice and LGBTQ rights with a liberal Christian than have to have a beer with an atheist racist, right? I mean, that's not something I'm down to do anymore. To me, and Chrissy Stroop is the person who I borrow this from. Shared values matter more than shared beliefs, and I think that's especially true when we're in a fight against white Christian nationalism. And I do believe that is the piece of the right that is ascendant right now. That is what we are seeing grabbing power. That is, I think, one of the primary drivers. And white Christian nationalism is largely a backlash against equality realized. Right? Conservative white Christian American status as the dominant group in this country is threatened, and it has been for a long time. They're losing the culture wars, which is a stupid phrase that I hate. Their ideas, their ideology are unpopular, remarkably unpopular. They are losing the privilege and, I think importantly, the deference which they believe they are due. And we know that when that happens, that when a dominant group or caste in a society feels threatened or feels left behind, that it overreacts by seeking a way to retain that status. And this is why we are seeing them turn to Christian nationalism, to violent insurrection, to the tearing down of democratic norms, to these so-called strongmen like Trump and DeSantis. That's also why we're seeing them seek to weaponize religious freedom. That they're doing all of that to prevent us from realizing those aspirational ideals in statements like "we the people." And there's some good studies that back this up that show that deeply conservative Christians who are accustomed to this deference and privilege, that they actually feel that expansions of freedom and changing demographics violate their rights, which is fundamentally not true, right? Parity is not oppression, and equality, even when it means the erosion of privilege, is not discrimination. Because the truth is, we're not actually expanding rights or giving out new rights. We are recognizing rights that have always existed, but we never enforced or the law never recognized. We're affirming the humanity of our brothers and our sisters and our siblings and admitting that we've been wrong. And I think as we realize the aspirational values that are implicit in "we the people" and in equal justice under law, which are the words that are carved into the Supreme Court, as we recognize that humans are human and worthy of rights, conservative white Christian America is dying this slow demographic death, and it's rebelling. It is raging against the dying of its privilege. And so, I mean, that is why they've declared war. I think that really is the motivating driver on their side right now, raging against the dying of their privilege.
Yeah. Way to put it. Brilliant. Brilliant. You know, and I really think that we need a whole lot more outreach education with the youth, because really that's where we're going to win it. Teaching the youth that just letting people be as they are and choose what to believe and think what they want to think ultimately, and having an open dialogue, or at least to be willing to have an open dialogue about whatever subject that might happen to come up, and you know, I mean, and look at things from a skeptic standpoint with a scientific inquiry. And if you want to look at something from a faith standpoint, well, that's fine too. Well, let's always challenge our views.
I appreciate the call, Arthur, and I'm gonna do something out of character for me. And I'm going to completely let you off the hook as a theist. I'm not going to ask you what that's about or have you defend it.
I know. I'm honored. I'm honored.
Call back another time when you're willing to actually engage on the subject. But I've got lots of legal questions to get to, so I appreciate your time. Thank you.
Yep.
All right. Couple quick announcements before we get back to calls. By the way, we do read all super chats over $10, and I cannot guarantee that Andrew will be able to stay for all of them or not. I haven't talked to him about how much time he's got for all the rest of this, but we will be getting to super chats.
Are you going to take your shirt off again?
If they super chat high enough, I'll do the show topless. I don't. Yeah. So briefly, here's the announcements. So tonight it's me and Andrew, and this doesn't happen often enough because you've been crazy busy. You know that Andrew knows perfectly well that he can get on this show whenever he wants. and which is one of the reasons why you messaged me the other day. And I was like, let's do it right now. Let's get it as quick as possible, because these are important issues. But also, I actually toyed with the idea of starting the show completely differently today. It's just, we didn't have time to talk about it, so I didn't do it. Normally, I do what I did today, which is let me give like a 5-10 minute, here's what's on my mind today, but I don't know enough, so I bring in an expert to tell you what's going on. I was actually going to I wanted the show to open with just Andrew sitting here to say, here's what's going on, here's what's on my mind. And I like to educate people who are clueless about these things. So let me bring Matt in so that I can give him I was going to completely reverse it today. But thanks for being here. We'll get back to calls in a minute. As a reminder, on this very network, On the Line Network, which is a call-in show network, not only do you have this program on Wednesday evenings at 6 p.m., on Thursday afternoons at 2 p.m. Central is the Transatlantic Call-In Show, where you or your family or your preacher or your bigoted best friend can call in and talk to real live trans people who will answer their questions, discuss the issues. They can ask the really awkward questions and say the really stupid things, and they can, if they absolutely have to, they can ask for really basic things that Katy and Arden and others have addressed, I don't know, a gazillion D1 times, because like me, they seem to have an almost never-ending supply of patience while they're on the show. But trust me, as someone who's partnered up with one of those two hosts and is down the hall, I know when the patience runs out, and she knows when my patience run out. And thank you, potential spam. I don't want to take your call today. It's somebody trying to buy my house. Somebody calls my number 4 times a week to ask if they can buy my house, and it's different people all the time. My house isn't even for sale, but who knows? Anyway, Katy and Arden will be on the Transatlantic Call-In Show tomorrow at 2 p.m. Central. Jimmy and I will be doing the Sunday show. That's Sunday also at 2 p.m. Shannon Q will host Skeptalk next Monday, probably with a special guest. I don't know who it is. Next Tuesday, Dying Out Loud with Dave Warnock, and the guest is going to be Forrest Valkai. So, I mean, I just had Forrest on the Sunday show. Next week's hang up is currently unconfirmed because we bumped Jim Barrows, who was going to be on here tonight, to make sure that we could get Andrew in while this Supreme Court decisions were still, really. Oh, Jim was in favor and recognized that we needed to inform this. He and I were just going to sit around and BS like normal. So maybe if Jim's available next week, we'll get Jim on. If not, we'll pick another Wednesday to get Jim on, because I love doing the show with Jim, and it's been a while, so we'll do it. Screening calls tonight is Ben. Thank you very much. And Cookies and a Morgan are modding chat. So yeah, we've got more calls. And Emily, somewhere in the southern U.S., pronouns of she, her, has a question about rights. So welcome to Emily. You're on the Hang Up with Andrew Seidel.
Oh, yes.
Hi,
hello.
Emily.
Thank you for taking my call. I love you both so much, but I'm going to respect your time and not do too much of that. So my question is kind of in regards to the definition of rights. I just want to give a little background. Months ago, I got into a discussion talking about my issues with my state's government, and I said, they're taking away my rights. Well, someone responded questioning what rights, and I said, I brought up my abortion rights have been taken away, which they have been. And they proceed to tell me, well, that's not a right. They claim that it isn't a right because it requires labor of another. And I'm like, what? How can I respond to that? And just one more thing. I was also told that since I have no distinction, I don't know any distinction between rights and freedoms, I shouldn't talk about politics. So I'm like, that's so condescending, but oh well. So those are my questions. Thank you.
Yeah, I mean, I initially think you should tell that person to get fucked is my sort of gut reaction. I mean, that's the kind of sophistry and nonsense. I mean, you are talking about a fundamental right or a fundamental freedom or a basic human right that you possess that is being taken away, and instead this person wants to focus on the semantics of it instead of the actual injustice of it. To me, I will say, like, Matt, I think, is one of the best debaters, so probably the best debater I've ever known personally, and could answer in terms of at least tactics and strategy and things like that, probably better than I could, for sure. But I mean, to me, that just seems like an utter non sequitur, right? If you're talking about your rights as a human being are taken away from you, and they're just saying, "Oh, well, that's not semantically, you're using the wrong word. You should be using freedom instead of right." I mean, that's just trash to me.
Yeah, it's just that I don't have any legal expertise. So when I was presented
Yeah.
that question,
Neither
I'm
do they.
Yeah, I think that's part of it.
But it's just weird to me, their definition of a right being that something that does not require the labor of another. And it's just like, I'd never heard that before.
That sounds a lot like the sovereign citizen people who are trying to define everything by, archaic laws and definitions of, oh, this is required. And I don't know, but I mean, that's what I feel whenever I hear that.
Yeah, it sounds like they're like very Ayn Rand to me, right? Like, I mean, and it also, I'm not sure what they're getting at, but labor is called labor for a reason, and abortion prevents that. So I mean, I don't really even understand their argument on a number of levels.
Yeah, that was an interesting.
Did you just completely do a pun with labor?
No, I mean, I don't think it's a fun. I think it's a reality. I've seen it firsthand. It's a lot of fucking work. I've never had to do it. I don't really know I'd want to.
Well, they brought up this scenario where they're like, so like if you were put out in, like if you were stranded on an island or something, and I brought back up, I'm like, well, what if I was early in pregnancy and I somehow had a pregnancy pill with me? They're just like, oh, who cares? I'm like, okay. Because like then it doesn't require anyone else's labor.
We're not stranded on an island. I mean, we're in what is supposed to be a civilized country that is governed by the rule of law, and we are losing that. And because we are losing that, people are losing their rights. That's what we're talking about. I mean, this is pure sophistry. Direct this person to me next time I'm online. I'm so sorry. Yeah, I mean, I know it can be very frustrating to try to have these arguments as a layperson, and that's one of the things that I always try to do when I come on these shows and when I write books and when I write articles. I try to break these things down into lay terms, and when I write, I try to give people arguments that they can use in their everyday conversations to rebut kind of nonsense like this. But this is. It seems so. I mean, it really does. I'm like wondering if that is not directly from Atlas Shrugged. Now that I'm like thinking of it, it seems very Ayn Randian. But
it's so wild because
the condescension. Sorry, go on that.
I have no way to prove it's from that, but I wouldn't have thought of that. But now that you mention it, it sounds exactly like that to me. Yeah, I could be completely wrong, but that's pretty cool.
Yeah, well, the condescension I've just felt in this entire abortion thing, like, the decision was leaked, and I was talking to people about, well, I need to leave my state. And, okay, I'm trying to remember. Well, they said, I got told just a couple of days before the decision was officially revealed that Roe versus Wade had been struck down that, oh, you don't have to worry about anything. I'm like, the decision has been leaked, and just this condescension, so much condescension on this issue. But anyway, I respect you all's time, and I love your books, Andrew. I've listened to all of them, and really your arguments are excellent, and I wish that our courts and our government cared about the facts of our history, but here we are.
I do too. Thank you, Emily. It's kind of
Thank you so much, Emily. I appreciate the call.
Thank you.
I've got follow-up questions for you, but there's people on the lines, and I'm going to keep taking the calls. Jeff in Seattle, friends, or him, has a question for you about First Amendment auditors and sovereign citizens, which that's a bunch of YouTube fun. So welcome, Jeff. Get your question in. Thank you so much for calling. You're on with Andrew Seidel.
Yeah, man. I prefer if you'd call me a nervous idiot rather than a sovereign citizen, because I'm just a nervous idiot. Last couple times we've talked,
I was wondering if you were the same guy, Jeff. I was wondering if you were the same guy.
Yeah, man. Yeah, man. I'm just
You're the
Go
guy
ahead.
who's called about First Amendment auditors in the past several
Yeah.
times now. Yes.
Well,
Yeah.
hopefully
Oh,
this
but
is a new
this would be
take
the
or a
third one.
different question. So let's get to it.
Okay, so I wrote it down. Basically, 1A gathers evidence of the lack of knowledge civil workers have about the law. And it can go from top to bottom. And basically, can we use the evidence that has been gathered over the years to create a legal necessity for civil workers? So instead of going to shoot your gun, for target practice, you also do maybe even twice as much studying the law and knowing the law, so we don't have these civil infractions that happen in all sorts of scenarios. Because there seems to be this swept under the rug of like, I just work for the government, and it's not taken as seriously, or there's like just there's many things that happen to these people that work in our government. Like, okay, Kim
Hang on.
Davis was
Hang on.
filmed. Yeah, go
Jeff,
ahead.
I thought you had a question, and I thought you wrote it down, and
I
you
did.
seem to be wandering all over. So let's just ask the
Can
question.
we use the evidence? I did. I asked, can the evidence be used to create a legal necessity to educate all who work for the government, so that there isn't these?
What evidence?
The First Amendment auditing evidence. I mean, Jeff. Here's the thing. If you want to do something with your time, there are far better things. There are like think of Emily, who we just spoke to, who is actually losing her rights. Spend your time doing that, not trying to expose. Let me finish. Not trying to expose the fact that government officials and bureaucrats are human beings who don't have at their fingertips a full grasp of First Amendment law. Like, I mean, that is not a useful thing for you to do. And if you are saying that there are plenty of government officials out there who don't have a full grasp of the First Amendment, I agree with you completely. I am a First Amendment attorney.
First
That is
Amendment
why I have a
lawyers who
job. Yes, I mean, most people don't, including a lot of First Amendment auditors too. But like, I'll leave that aside for just a moment. Like, my objection is that including this question, is generally a waste of my time. I think there are so many better things that you could be doing, especially when it comes to if you want to enforce the First Amendment itself, than just trying to trap these folks in it.
Okay, Jeff. Jeff.
That wasn't the question.
Jeff, listen real close. I'm going to let you go now. You can call back another time. But if my guest thinks something is a waste of his time, I care more about whether he thinks it's a waste of time than whether or not you feel you've been wronged for the 14th time or 13th time that you've called.
No, I asked that the evidence be used to create a legal...
I don't know why you decided that it's fucking wise. I don't know why you decided it was fucking wise to talk over me when I said you could call back another time. Should I ban you from the show? That was a question
I asked, man.
That was a question.
And you didn't answer my question.
I don't know why
you didn't answer my question.
Goodbye, you're banned from the fucking show, you jackass. Listen to me. I entertain these questions all the time. All I said was we're going to move on because of my guest's preference, and you could call back another time. But Jeff, you decided to be a whiny little bitch just like you are when you're First Amendment auditing. You're done here. Don't call back. All right. So moving on, we have Lee in Australia, who I'm assuming that you are not an expert in Australian law, so maybe Lee's calling about this. But Lee in Australia, pronouns are he, him, a question about legally being able to refuse businesses that might violate personal ethics. So Lee, you're on with Andrew Seidel. Ask your question.
Yes, hi. Pardon me. Hi, Matt and Andrew. Great to speak to you.
Hi, Lee.
I just wanted to get you guys' thoughts on a dilemma that I find myself in. So I'm a draftsman, so I do building drawings, and I have a client who has asked me to do some drawings for an educational facility, which I have agreed to and commenced that project. And turns out that the organisation happens to be the Church of Scientology, which obviously I'm an atheist and I have a lot of objection to. But based on your comments at the start of the show about the Supreme Court in the US and their judgment on whether businesses can refuse, people's patronage based on race and religion and those sort of things, where do you think I would stand if I was in the US in regards to that issue?
It's a good question. I was worried you were going to ask about Australian law, but since you've framed it that way, I think the number one thing that is useful here would be to talk about how civil rights laws work, especially in the United States, because most Americans don't seem to understand how these laws work at all. And again, there's a better, deeper dive of this in American Crusade for anybody who is interested. But the basic idea of the laws is pretty simple. Don't discriminate. Okay, but how does that actually function under a civil rights law? Who can't discriminate and when and where? And why can a business, for instance, put up a sign that says no shoes, no shirt, no service, when that so clearly discriminates against nudists? Okay. So this case that just happened and the gay wedding cake case, together with that widespread unfamiliarity with civil rights laws, it bred like 1,000 of these bad kind of gotcha analogies. I'm not suggesting, Jeff, Lee, that yours is. Things like Nazis and Jewish bakeries and bacon and kosher delis and the KKK in black-owned businesses. There was actually, during oral argument for this case, there was a Black Santa and KKK kids hypothetical that Justice Alito trotted out that was ridiculous. But understanding how these laws actually work disposes with most of this. So civil rights laws in the United States operate in basically the same way. First, they list groups of people who are protected. Okay, and those groups of people are known as protected classes. So in the Colorado case, Colorado's Anti-Discrimination Act protected several classes: disability, race, creed, color, sex, sexual orientation, marital status, national origin, and ancestry, I believe, which is more than our federal civil rights laws, than the U.S. civil rights laws. So those protected classes are statutory. They're established by law. They can be added to or taken away by legislatures. Then the law lists businesses, places, and services and the like, which we call places of public accommodation, that cannot exclude those people. Okay, places of public accommodation. Finally, the laws do not, as Matt and I discussed earlier, require any business to provide a specific service, only that any service they provide is provided equally. Okay, so any good analogy or any question that you want to ask, it has to have a protected class that is actually protected under the law, a place of public accommodation, and a service that is being provided to others but being denied to people in the protected class. Okay, now most of the analogies that we have heard in the news and that we heard in the case and even in the opinion, and certainly during oral argument, a lot of them, for instance, didn't involve protected classes. My favorite examples are the ones when people bring in the Nazis, right? Because fuck the Nazis. Nazis are not a protected class, so a business can discriminate against them. Bigots are not protected by the law. Political affiliation, to go back to Matt's MAGA hat example, is not a protected class in most jurisdictions. You can say you don't want to serve Republicans in a jurisdiction that doesn't protect political affiliation. Other analogies miss the mark by failing to center on a place of public accommodation. And this means a public business, something that is to be open to the public. So your house does not count. To go back to the Masterpiece Cake Shop case, right? A business in a strip mall that is open to the public is different than a baker in his house baking a cake for friends. Now, an artist often isn't going to count as a place of public accommodation. Steven Spielberg actually pops up in the opinion of this case. And I think it's kind of a really good example. Like, he is not a place of public accommodation. He is a guy who gets to decide how he wants to work and who he wants to work with. He's essentially an artist. By the way, we didn't talk about this, Matt, and sorry, Lee, I'm going to do a little aside here, but there was another really telling point in the 303 creative opinion And the ultra-conservative majority uses two cases to make its central point about free speech. And in neither of those cases was the organization at issue a public accommodation, right? So the majority used one case called Hurley and another case called Boy Scouts of America versus Dale. And in Hurley, that involved a privately organized and privately run parade. And therefore, that parade was able to decide whoever wanted to join it could join it. Boy Scouts of America is famously a group that discriminates, still against atheist children, but it has been declared a fully private organization, even though it has a congressional charter. So just an interesting point that the majority in that case had no precedent that it could point to about basically because it was busy gutting it, 60 years of it. Anyway, okay, so finally, other analogies fail to understand the third aspect of it, that service requirement. So if, and Matt and I talked about this already, if a business provides a service, it must provide it to all members of that protected class. Right now, civil rights laws do not tell a business what they are required to sell, only that if the business does sell a certain product, it can't refuse to sell it to certain classes of people. So this came up in the Masterpiece Cake Shop case. It might have actually been a Chicago Tribune op-ed, but like the government can't force a kosher deli to serve bacon because the kosher deli never served bacon. But the government can tell a kosher deli that it has to serve, a pastrami on rye to black customers, for instance. So that is basically how the laws work. There is one more caveat to these laws, which I think is really, really interesting, and that's that public accommodation laws, civil rights statutes almost always exclude any, quote, place that is principally used for religious purposes. That's how the Colorado statute phrases it, from the definition of a place of public accommodation. So even though churches and synagogues and mosques and houses of worship are open to the public, they can still kick out gays and bar the church doors. They don't actually have to worry about forcing homophobic preachers to pronounce their marriage vows because they're not considered places of public accommodation. But businesses organized and protected under the laws of the state have other rules to follow. So for me, the question would be, are you, Lee, a place of public accommodation? And are you under whatever the state you would be considered a place of public accommodation? And I don't know the answer to that. My gut is maybe not. And maybe you are. I don't know. But if you are, then yeah, you have to provide services equally to folks that ask for them. Now, if you don't design that kind of building generally, or your schedule is too full up to take that on, that's totally fine too, right? If you don't design that kind of building, then that's not a service that you provide to others. If your schedule is full and you can't take on any business, that has nothing to do with them being of this particular religion or not. So there are a bunch of different things that can happen in these cases that are unrelated to the way the laws function. But hopefully that clears up a lot of the misunderstandings that people have about this case and about this kind of law generally. Did that help, Lee?
Yeah. Well, I mean, I understand what you're saying, but if I was in the US and under my situation that was signed up to provide my service for this particular project, had commenced that, and then that fact of the religious aspect was made to me after that. So I'd already been paid for and started on the project. How would I fare in the US if I backed out of that based on the religious context? So are they one of the protected classes?
Well, religion usually is a protected class. And that list of characteristics that I read out earlier, disability, race, color, sex, sexual orientation, creed is the one that covers religion in Colorado law. Other states define it in different ways, but faith, religion, something along those lines. I mean, I think you'd be more fucked under contract law, given that you've already started it, and there are a whole bunch of common law things they could come after you for too. So from a legal standpoint, that wouldn't be something that I'd be terribly. If I were your lawyer, I'd be more worried about other things. But I mean, the key question for your case would be if does the civil rights law apply to that situation? Would be, are you a place of public accommodation, or are you more like, as I mentioned, the sort of Steven Spielberg kind of person in that scenario, which I think yours is a good example of like a place where you might have to have some litigation to figure it out, where their reasonable minds could differ on that.
Yeah, okay. Well, thanks very much for that. It actually turns out that that there's a separation between what I'm doing and the church itself. So the people that will be running that organisation that I'm doing the work for are not affiliated with the church, but are working within the property of the church. So, it's kind of given me a bit of a moral out clause, which might sound a bit of a cop-out, but yeah, I appreciate the advice that you've given me. Thank you.
Not legal advice either, just an explanation of American law. Just
yeah, of course. Yeah.
Okay, all right, good. Thank you, Lee.
And can I just finally say, Matt, is it still the hang-up?
It is still the hang up, and you're definitely not allowed to hang up with me, even though you probably think you can.
Oh, I was going to.
Oh, you should. No. I was teeing it up for you to hang up on me.
Oh,
spite of my
Matt, please. No. And you're done.
There you go. See, I bet you didn't hang. Oh, wait, you did hang up. I was like, for a second there, I was like, I bet he forgot to hang up, because some people are so excited to hear the end of it that they don't get around to hanging up. All right, last call, and then we're going to super chats. Chris in Wisconsin, you are live on the Hang Up with Andrew Seidel.
Hi, thanks for taking my call. I will be really quick. I just wanted to know Andrew's opinion about the ICWA case. I was really surprised that this court decided to uphold it.
So for the folks who don't know, ICWA, the ICWA, I think I might have mentioned this at the beginning, but ICWA is the Indian Child Welfare Act case. The case itself was Holland v. Brackeen, and I may not be pronouncing that correctly, so I apologize if so. But I mean, I was not surprised by Gorsuch in that case. I don't think anybody who watches the court really was. I mean, this was a law again. It was passed to end the forced assimilation of Native American kids into white families, and the people challenging it with help from states were basically white couples who were claiming that act was racist. It was very similar feel and vibes to the affirmative action challenge. I did think that Gorsuch might have been with the liberals, and it would have been a 5-4 decision. So I was pleasantly surprised, but I will say there were so many cases going on this term, and I was following two of them very, very closely, and two of the cases for the organization I work for, Americans United for Separation of Church and State. The court was considering taking, thankfully did not. That I wasn't able to dive into that one as much as I wanted, so my predictions there were no better than the average kind of court watcher. But I was definitely pleasantly surprised that it withstood the challenge, and that ICWA survived. And it seemed like there's a couple of tribes here, or at least one tribe here in Wisconsin that was involved in the case, and everybody seemed to be celebrating without much reservation. Like for instance, on the Moore versus Harper, the independent state legislature case, like we're all pretty happy about that one, but there's also there are these kind of some dark storm clouds that you can see gathering in that opinion, and I haven't seen anything that suggests there's something similar in the Indian Child Welfare Act opinion. So yeah, I think we can call that one of the instances of the Supreme Court rules that puppies should not be drowned doing the right thing where they should do the right thing.
Okay, thank you for taking my call.
Hey, Chris.
Thanks, Chris.
Before you go,
Yes. Yes.
just for next time, so your mic is incredibly hot. So I don't know if like you're on a mic that's right up next to your mouth, or if the phone's really close or it's turned up or whatever. When you call back next time, just move it a little further away from your face, because it's peaking the meters and it makes it garbled and harder to understand. So just for next time.
Okay, thanks.
Thanks, Chris. All right. We have finished the call-in portion of this wonderful episode online. We've got super chats, and we will alternate. I'll let you go first, although I think I might just wind up teeing up a bunch of them for you.
Okay, hang on. Let me get my... Okay. From Yves Simard. I don't know. I apologize. If Supreme Court justice is accepting lavish gifts and holidays is not grounds for impeachment, then what is? I don't think the question is what is grounds. I think the question is whether that is likely to happen.
Yeah. It's like, okay, here's the thing. I'll say something just so that somebody can clip it. If Hunter Biden has actually broken the law, prosecute his fucking ass and throw him in jail. I don't care if he's the president's son. I'm not looking for favoritism, but Hunter Biden isn't the president or any elected official in the government. Take him the fuck out. But there's a difference between what's likely to happen to Hunter, no matter what he did, because of who he is. He's the son of a president. Is he probably not going to suffer as greatly as he could have under other circumstances? Absolutely. And I think the Supreme Court justices are likely to be in a similar position because of who they are. There are some concerns, by the way, of actual elected public officials and Supreme Court justices appointed for life in how the law handles it. There's a reason that Ford pardoned Nixon. And I think that there's a non-zero chance that even if Trump were to be convicted, there would be some sort of pardon as a possibility. But I don't know. So, all right. Let me go back here to number one. There we go. I'm queuing these up. $10 from Zacuse. Is 303 the double-edged sword cleaving the way to segregation 2.0 that I think it is? Can protected classes refuse to serve non-protected classes on the same precedent?
Yeah, I mean, again, I don't think there's any limiting principle to that decision whatsoever. A lot of the logic in it is separate is equal. You know, Matt, you kind of touched on this in the beginning, and I assumed we would get a question on it. But the idea that like she'll serve gay people for sure. She just won't do a gay wedding. Like, I mean, I would encourage everybody to read Sotomayor's opinion. Dissenting opinion, just eviscerating that logic, as I believe she called it, embarrassing. That is the same logic that got us separate but equal. My great fear is that there is no limiting principle in this case. You cannot distinguish the different kinds of discrimination, and we know that the bigots are going to be emboldened, and that the Christian nationalist organizations out there are going to be, the Supreme Court opened the door. They're going to be rushing through, bringing case after case after case. I mean, yes. I mean, I think we are going to see absolutely cases in which racial discrimination is justified using this decision. That is 100% going to happen.
I also, I think Ben Shapiro, in the process of commenting on this, tried to make a very, very similar line of argument, basically saying just because a law happens to discriminate against homosexual activities or acts doesn't mean that the law discriminates against homosexual individuals. And James Croft, a good friend of mine in the UK, who's wonderful, replied with something along the lines of, yes, what a terrible coincidence that all of these gay men just want to have sex with other men.
Yeah, I mean, there's a famous civil rights case. I think Sotomayor even mentions it in the opinion, where a restaurant said it would serve black people if they came to the back door and stayed away from being out front with the white customers, right? It's the same kind of logic. She also said, something along the lines of, there's another very famous civil rights opinion called the Heart of Atlanta Motel. And she basically said, oh, look, black people could still rent rooms from their white friends, right? Like you can have the white people go in and get a room, and then it's just the most ridiculous. Like, of course you're targeting gay people by saying you're not going to do a gay wedding. It's just it's idiotic to suggest otherwise. Anyway, go read Sotomayor's opinion. She guts it pretty clearly.
I'll take this one just because it's.
Okay.
Go ahead.
10 from Sheridan Bernasconi. SCOTUS ruled on a what if. That's fucked up. Thank you, Matt and Andrew. It was a what if. It was the hypothetical.
Yeah. When you said that, I mean, I hadn't spent enough time on this case to really grasp that. There were bits and pieces of things I was getting, and then I realized, oh, not only is there a fictional client, but and a lie about a client, but there's no client, no website, no nothing. This is just, hey, I'm thinking about doing this, and it made it all the way through the Supreme Court. And oh my God, yeah.
If you want to see how divorced from reality and unhinged this case was, go listen to the oral argument in the case, which you can do on the Oya's website. It is an insane oral argument because all it is the justices coming up with more and more outlandish hypotheticals because there's nothing to focus on. There's no facts in the case. Nothing happened except now the Supreme Court gutted civil rights. Anyway.
When they rule on, so the number of times the Supreme Court's turned down cases because somebody lacks standing or because you can't point to any actual harm or anything like that, and now they're deciding on a fictional case. Mm-hmm. Shit, I forgot what I was going to say, but it was going to be good. It was going to be really good.
And standing is for suckers, and now that they have 6 justices for a supermajority, standing doesn't matter.
Oh, what? How is it not the case? All the people talking about judicial activism, legislating from the bench. How can this be anything other than legislating from the bench and judicial activism when there's no fucking case, there's no client, there's no business, there's no nothing. It's just, hey, we're going to take a hypothetical so that we can change the law.
That is absolutely all it is. I mean, there's in a lot of these cases, that's what it is. I mean, the student loan case centers on the justification in that case, centers on something called the major questions doctrine, which is not a doctrine at all. It's just a creative marketing label for bullshit. Basically, it's like if the court thinks something is a big fucking deal, they can do whatever they want. So the court quoted in that opinion a writing that said, loan cancellation raises questions that are personal and emotionally charged. And I think that's honestly, that could be the most telling line of the Supreme Court's term last week, right? It's a confession that these are unelected politicians who are serving for life, and they're going to do whatever they want if they feel like it, right? That case gave them the feels, personal and emotionally charged, and so they just said, you can't, President Biden and Department of Education, you can't do what the statute clearly allows you to do, which is compromise, waive, or release any right, title, claim, or lien or demand during times of war or national emergency, like, say, a pandemic, right? We're just going to invent some nonsense because we feel like it. It is judicial activism and legislating. Anyway.
I have a follow-up question on that, but let's get through the super chats here. 1999 from Steve Kudlenius.
Hi, Steve.
Kudlenius. God damn, I'm so sorry, Steve. I'm going to butcher that. I'm usually pretty decent with him, but Steve says, I really wanted a super chat. Yeah, I really wanted a super chat $22.99 for the low price of American Crusade. Andrew, is America's standing and reputation going downhill on a global basis due to these rulings? So there's a softball.
Yeah, I mean, 100%. We are going backwards. I mean, we are rolling back civil rights. I mean, here's one thing that I was thinking about last night. There's a lot of things that keep me up, and this is just one random thing that kept me up last night. Is you're going to see other countries and non-governmental organizations reporting the United States to the United Nations for human rights abuses because of these decisions. That's going to be happening.
Wow.
Yeah. Oh, me, Jake Jones. Excited to watch today's show tomorrow at work. Keep up the great work, Arden, GFY, Jimmy, and Matt, YGH. Thanks,
GFY
Jake.
is go fuck yourself.
What's YGH? You go home? No. You.
Oh, you're gay, homie. So, long story, has to do with somebody attacking me over my relationship, and it was after correctly gendering my girlfriend, then just decided to say, "You're gay, homie," and it's just fucking hilarious, as if I would have a problem saying if I was. It's just weird. But yeah, thanks, Jake. 1999 from Greg Murkowski. Roberts doesn't realize that if the Supreme Court's going to play politics, then they're going to be criticized. And for now, we have freedom of speech and we'll use it to express our displeasure. Fuck Roberts. I don't think he cares. I don't think. And actually, I don't know. Maybe I'm wrong here. I'm not convinced Roberts is the problem. I mean, should be, but I don't get that feeling.
No, I just wrote about this on my Patreon last week, I think. Roberts is actually a brilliant politician, unfortunately. Roberts can afford to play the long game. He understands that he can afford to play the long game, I think, better than any of the other justices. The thing that he most understands is that preserving the conservative changes that the justices are making from the bench depends on the public perceiving the court as a legitimate institution, right? So if the 6-justice ultra-conservative majority wants to preserve the conservative change that they are out to create, it has to be perceived as legitimate. So Roberts is an institutionalist, right? He cares about the court as an institution, according to the media. But that's true, but it's not because he cares about the court as an institution per se, but because the court must be a credible institution to serve his conservative goals. And this is really a finer point that I think a lot of people miss. It's worth spending a little time on. Roberts values institutional legitimacy not as an end in itself, but as a prerequisite to lasting long-term conservative change. And his patience and his realistic grasp of his power, not to mention he's a pretty damn good writer, unfortunately, I think make him the most effective conservative politician in the United States in the last 20 years.
It's like when Rick Perry was governor of Texas, but Rick Perry's an idiot and Abbott is not. And so Abbott can do far more harm than Rick Perry was going to do. And he is. I'm going to ask my follow-up, even though we've still got a lot of super chats left, because I think I know the answer. Let's say Sotomayor, Kagan, and Jackson. What's to keep them from just saying, this court is activist and fucked, we're not going to participate?
I mean, that's an interesting question. We've not seen something like that. They are starting to do, I guess you might call like the Supreme Court equivalent of some of that in I think it was the student loan case. Kagan wrote in her dissent that the majority opinion was unconstitutional. Now that may seem like a small thing. I call shit unconstitutional all the time, but to hear a Supreme Court justice say that against the majority opinion in a case, I've not seen something like that. Other like minor things that you're seeing changes to, justices often always, when they dissent in cases, they respectfully dissent. Those are the two words that therefore I respectfully dissent is how they usually end things, something like that. And now they're dropping the respectfully off this, especially in the race cases that have happened.
So they're doing what I suggest, but they're doing it within the bounds of maintaining some respect for the court, so that it's not like burning the whole thing down.
Oh, yeah, I mean, also, don't forget, these are women. They're women of color. They are held to an absolutely, and because they're liberals, they're held to just a much different standard than somebody like Alito, who has the thinnest fucking skin of any politician out there and runs to the Wall Street Journal when he knows there's going to be a news story that breaks about whatever scandal he's involved in and publishes an op-ed. I mean, if one of the liberal justices did that, I mean, there's shit that would rain down on them is just, it'd be unbelievable. Anyway, yeah.
All right, continuing on, $49.99. That's incredibly generous. Thank you so much, Marissa. Hi, it's Marissa from Patreon. Is the emphasis on the right to speech maybe establishing a foundation for a case to be brought arguing against God being on our money? Obviously not this court, but all things being equal otherwise.
I I mean, it's certainly an interesting thought, and I think people are going to take. I mean, it's a pretty maximalist decision, but we also know that this court, as you point out, doesn't care about those kind of things. There is no establishment clause with this court. I don't know what right you would be arguing is violated. I guess you would say your free speech is. You don't want to say those things. That argument has been tried even without this precedent in place. It's been Mike Newdow's been kind of testing jurisdictions with various arguments, including that one. I mean, I do think there's going to be a time when God is going to come off our money, but I think it's going to be not because of a court case. And Marissa knows this because she's on my Patreon, but this is something I say all the time. Like, we can no longer think of the courts as the solution to any of our problems. They are the killer of solutions to our problems. Oh, 20 from Dane Ballo. I figured it's about time I give some support for the hours of free, amazing content you all make. Amen, Dane. Please continue the HOSTility from Monday on this channel. It was great. Love ya, Matt and FYJ. Is HOSTility right? I am assuming it is.
Yes. HOSTility is one of the shows that Jimmy does from time to time on here. And I think we filled in Monday. There wasn't a Skeptalk, which is the normal Monday show. And I think Jimmy did a HOSTility then. So
HOSTility, nice.
$10 to Joshua Everett. I'm fully shocked that the Roberts Court didn't try to overturn Obergefell with the 303 creative decision. This court would be rightly reviled by history as a fascist joke. I don't think they can. I'm talking out of my ass right here, but I don't think they could have taken what they did with 303 and said, oh, by the way, we're also going to now overturn Obergefell.
But I believe it was Mark Joseph Stern who I saw first point this out and then ran to check the opinion, and he was correct. The court in the 303 case does not mention Obergefell or marriage equality as a right, which is, to me, a big fucking warning flag. Not that there weren't warning flags already. I feel like I've been screaming about this since Brett Kavanaugh was put on the court, certainly when Amy Coney Barrett was put on the court, that they are coming for abortion, they are coming for contraception, they are coming for marriage equality. They have the votes on the court to overturn marriage equality. This case, Matt's point is that this case was not a good vehicle for that, and I agree with that. But the fact that they didn't mention Obergefell v. Hodges or cite it is very alarming, terrifying, in fact.
Yeah, and Kavanaugh might as well have just sat there and said, I like beer and not queers, because we all know that that's the point behind a good chunk of this. Continuing on.
$10 from Random Access, excuse me. Roberts is really cementing his place in history next to Chief Justice Taney, indeed. For my question, could SCOTUS just rule that the concept of protected classes is unconstitutional? Well, that's interesting. Yeah, I mean, I think that would be in line with some of the affirmative action language, for sure. Yeah, I think I could foresee people and these organizations on the right taking a case arguing that the very concept of protected classes violates the Equal Protection Clause, and 6 justices on the court buying that. So that's a new terrifying nightmare for people to think about. Thanks, Random Access.
Although now that we've said it, I was like, you'd need a case for that. And then I realized, oh, wait, there's a Christian Dominionist organization that's going out and fucking manufacturing whatever the case they want. And now they just got them to take hypotheticals. So yeah, they will manufacture this hypothetical case tomorrow if they weren't already planning it.
The one thing I will say is, they have a license now to just ignore civil rights laws when they want. So they're not going to be happy.
They're not going to be happy until the only protected class is Christianity. That's it. Not religion.
Yep.
Christianity. $10 from Larry Fishman. In a rightist reactionary empire, the law is an artifice meant to control the proletariat. The powerful are understood to be above punishment unless they harm other powerful people or the state. I can't even say you're wrong.
Yeah. I mean, one of the ways that I've been thinking about what the project of this court is that they're trying to drag this country back to a time when conservative, white, cisgender, heterosexual Christian men ruled. when that group was protected by the law but not bound, and everybody else was bound by the law but not protected. And I mean that's worth what the project they're working on is. I got this one, Matt. $20 from Erica Marica.
That's perfect. I try to make sure I tee you up some easy ones. Thank you so much, Erica, and thank you, Larry, and everybody else. We're trying to get through so many of them, and you guys are being incredibly generous, and I want to be good with Andrew's time since we've run over.
You can blame me too, because I'm a lawyer and I like to talk, and I have a large captive audience right now. So
I thought you meant you can blame me for why we have so many super chats, and I was like, yes, I will blame you. I will blame you for all the super chats. You're just terrible getting super chats into the show. 999 from Mel Tree Fitty. Have you bought Andrew's books yet? I know you're not asking me because I have all of them. So yeah, why don't we take this opportunity? Is there a link down below? And if there's not, let's make sure somebody gets a link to Andrew's site so that you can get your copies of the books.
Yeah, the books are The Founding Myth, Why Christian Nationalism is Un-American, which if you've ever been in a debate about the Founding Fathers or the Constitution or the Declaration of Independence, which you probably were yesterday, or America being founded as a Christian nation, right? Like that book will give you all the facts and arguments you need to end that debate. And then just a couple months ago, American Crusade, How the Supreme Court is Weaponizing Religious Freedom came out. And Mel, I guess I owe you like a drink for that softball. Thank you.
Awesome. Possum. Here we go.
Do you have a website or a link or something you want?
I just sent it to you.
Oh, okay. Cool.
Thank you.
Can
I also
third
I tell people to go to bookshop.org if you're going to buy books. If you don't know about bookshop.org, it's the ease of buying your books online, just like that other website run by that other billionaire asshole, but you actually support your local bookstores instead. So just something to think about.
I got you this one.
Oh, thank you. $9.99 from Trevor Stroop. Trevor, you rock.
But Trevor sent a follow-up, which I'll also let you do.
Trevor says, is the Americans with Disabilities Act at risk? Is I'm assuming what you're going for there, Trevor. I don't know enough about that to weigh in on that. I will say that every law and statute we have is in danger of being riddled with exceptions for conservative Christians, which is what American Crusade is all about.
Yeah, it seems that one of the things, well, I was going to ask, what's the best course of action for the people watching to help unfuck the courts, and what do our elected representatives need to do? But in the same way that they need to start passing laws that codify some of these things that are being taken away, like if the Supreme Court guts affirmative action, then our elected representatives need to work to protect it and codify it right away. And apart from calling your representatives, doing everything you can to support, I don't know, packing the court, stacking the court, unfucking the court, getting laws made. I mean,
unfucking the court has to be priority number one, because like no matter what policy solution we come up with for, okay, the court overturned Roe versus Wade, fine, we'll pass the Women's Health Protection Act. Great. What's going to happen when the challenge to the Women's Health Protection Act gets to the Supreme Court? Right? Like no matter what we do, no matter what solution we come up with, everything is going to lead its way back to the Supreme Court eventually. And if you don't believe me, think of what we've been talking about this term or this show. Like the court does not care about facts. It does not care whether there's actually a case. It does not care whether there's actual victims involved. They will take cases that they want to decide. And if you think they don't want to decide that abortion is unconstitutional and people don't have a right to it, as we talked about with that fine caller, I mean, you're crazy. They're doing what they want to do right now. That has to be, I think, the number one priority for all of us, is fixing or unfucking the court. And I think that's what you need to be screaming at your politicians about.
Another $9.99 from Trevor Stroop. I rarely get to watch live, Matt. You're awesome. Fuck you, Jimmy. Thank you so much, Trevor. And, thanks for doing multiples in order to get your messages in.
$19.99 from Daniel Romero. Saul, Matt and Andrew, I'm leaving the U.S. for a while. Don't let it become a theocracy. Look, Daniel, I'm doing all I can, but you may want to consider buying property wherever it is you are going.
It's going to be difficult. $123. Wow. From John Kennel. I used to watch First Amendment auditor videos until my doctor warned me about my blood pressure. So I switched to sovereign citizen videos until my doctor warned me about my blood pressure. Now I watch you guys, ... Well, this should be good for your blood pressure because I have very little patience for sovereign citizens and First Amendment auditors. And Andrew's already just stated today that it's a waste of his time. So we'll save your blood pressure. It's worth $123 for us to save your life, John.
Yeah, small price to pay. That ellipsis is doing a lot of work in John's super chat. I love
it. It is. It's heavy lifting, but thank you so much. I appreciate your generosity.
$10 from Hystario. Should Biden pull in FDR and tell the Supreme Court, you and what army? I think you might be thinking of Jackson. FDR is the one who threatened to expand the court. And I do think that Biden ought to start thinking. I'm sure they're looking at those historical analogs, and if they're not, they should be, but I'm pretty sure they are.
Yeah. $10 from Larry Fishman. Can you explain the new history and tradition test SCOTUS is using these days? Has it always been a thing, or is it a new excuse to block human progress?
Really great question, Larry. I actually just wrote yesterday, or it was published yesterday, an article on Religion Dispatches called "The Traitor Who Gave America Prayer," which is all about, we have government prayer at so many of our official meetings, right? At your city council, the U.S. Congress has prayers before it. And how the fuck did we get that in a country that separated church and state? The first country to ever separate church and state. And the answer to that is there's a 1983 opinion called Marsh versus Chambers where the Supreme Court upheld these kind of prayers. And they used the first version, really, I think, of the history and tradition test. And one of the things they pointed to was a prayer at the Continental Congress in 1774. And that prayer was given by a guy named Jacob Duché, who turned out to be a traitor. He was a traitor to the American cause. And the court lifts this prayer up and talks about it, and you hear Christian nationalists talk about it all the time, and it's this great moment. And they never follow up with the fact that this guy was a traitor or mention that it was 1774, which is, like 15 years before the Constitution that separated church and state was ratified. And it might be a stupid idea to use that prayer that was a decade and a half before to interpret a document that hadn't even been written yet, but whatever. Anyway. That's the history and tradition test. It's garbage. It's nonsense. It's cherry-picked history to guide the court in a direction that the conservatives like. I mean, if you want to look, like a perfect example is the Dobbs case, which overturned Roe versus Wade. The history in that opinion is just absolute, utter trash. And yet that is what the court is relying on. So yes, it is absolutely selective. So it allows the court to focus on the things that it finds helpful to justifying its position and ignore everything else. And it allows them to, do what Matt and I were talking about, which is legislate from the bench. And as you point out in your super chat, Larry, a new excuse to block human progress, because we all want to be living in 1789 when life expectancy was 40, and we didn't know basic science, and women weren't people, and neither was anybody whose skin wasn't white and not from Ireland, right? It's ridiculous. Anyway, okay, I'm ranting.
That kind of thing continued. Because wasn't it McCreary where Breyer basically invented a grandfather clause of this Ten Commandments monument needs to go, but this one can stay because it's been there for ages with nobody really complaining about it. So.
Yeah,
it's not the first time that somebody basically invented something that intuitively seems like, oh yeah, of course that's the way the law should work, but has nothing to do with the actuality of the law. And now it does.
Yeah.
All right.
Yeah.
Oh, I lost my
guiding in second minute. $4.99 from Damian Johnston. What value does atheism have to the left? Is there a worry of it pushing away working class people whose interests may align with leftist values?
So first of all, I have no idea how your super chat got in here at that low. But second of all, I'm confused by the question because atheism is this position of not being a theist, of not accepting theistic claims. Whether or not it has any value to the left or the right is completely irrelevant. It's a factual position. You're either convinced that there's a God or you don't. Atheism is not a strategy. It's not, somebody asked me the other day, why are you an atheist if you know we're going to lose? And I'm like, because I'm not picking a fucking strategy. I'm not convinced that there's a God. And so I'm going to identify as an atheist. That's it. Is there a worry of it pushing away working class people whose interests may align with leftist values? I don't care. I'm working class. But even if I wasn't, I genuinely, I'm not trying to be a dick or anything, Demian, but you're comparing apples and oranges here to talk about a strategic potential conflict. Like, is atheism pushing away the working class people on the left? You know what? It might be. You know what? Supporting trans rights might be as well. I don't give a fuck. I'm not here to strategically find a way to allow bigots to feel like they're doing good things. And I'm not sitting here. I have no objection. If there's somebody who's a God believer who wants to work with us towards good outcomes, I'm with them. And I'll argue with them tooth and nail about whether or not there's a God after that. But yeah, this question doesn't matter.
Yeah.
My apologies.
I'll add one thing to it, which is just, but I mean, secular voters, and however you want to define that, non-religious, atheist voters, right? Like, there's a bunch of different ways. Like, that's actually one of the strongest growing demographics. And really, there's a lot of political power on the left coalescing around non-religious / secular voters. And I recognize that there's a lot of problems with the labels I just used. But it is a growing political movement, which I think would undercut to the extent that second question suggests otherwise. Anyway.
Yeah. Anyway, what'd you say, Arden?
I just said it was my bad. This shouldn't be in here, and it was an accident. So, anyway.
Sorry. I'm glad I get to ask it because maybe Demian has some thoughts. And by all means, I'm not asking you to throw in another super chat or anything else, but I may have missed something in your question, Demian. That's always a possibility. So maybe give a call back next week and talk about, atheism and the left, because genuinely it's like saying, hey, how does your disbelief in the Loch Ness Monster impact the strategy of the Democrats? And that just doesn't resonate with me. But if I miss something, cool, call in. I'm happy to talk about it.
$10 from Robin Webster. So, was Alito the leaker? LOL. Thanks, Andrew and Matt. So sick of this court. Biden needs to promise to support expansion. When is your next book? Oh, goodness. So I think smart money would be on Alito being the leaker. I don't know if we'll ever know, though I do think there are some hints that it was him. And right now, there are no plans for a second book. I have did American Crusade to reflect the last Supreme Court's term, which is on my website, andrewlseidel.com. And I will likely do the same thing for this one for the paperback. So you're going to have, the problem is the court's doing so much with religion. It's like, I need like another 50% more of the book. And I don't think my publisher is going to let me do that. So I don't know. I have ideas for a second book or a third book, but it's actually a fourth book, but we haven't, there's nothing settled.
$10 from Stephen Saunders. Thank you very much. Do this now set a precedent for the court to continue deciding on hypothetical harms, or is this question meaningless since SCOTUS will seemingly do what it wants?
The latter. Yes, Stephen.
I mean, why can't they both be correct? Yes, it's going to set a precedent, perhaps not a legal precedent, but a historic precedent, so the court can keep deciding on hypothetical harms because that's what they want to do. Yeah. Thanks, Stephen.
Mm-hmm.
That is absolutely. This is. I shit you not. I said this many times in many different forms. when I wake up, I check on the animals. I go downstairs, I sit down in my chair. I don't have standard cable anymore, so I don't have the news channels. I tend to just watch YouTube, and I watch some news stuff on YouTube, and I see what the highlights are, and then I go on my phone and I check news. Genuinely, there hasn't been a day that I can recall, apart from like when I was in the hospital after heart surgery and it wasn't able to do it, where I've sat down and not gone, is this reality? What's happened over the last 7 or 8 years, including things that I would have bet my life couldn't happen, are happening. And I still want to maintain some cautious optimism that what we're seeing are the death throes of the great dragon of religion, that this is it flailing around in its last gasps before it dies. But let me tell you, if those last gasps are fire breathing, it's going to take out most of the village with it, and it's terrifying.
This is another 10 from Robin Webster. I was surprised by the voting map case. Do you think Roberts convinced Brett to side with him to soften the blow on the last 3 cases? My hero, Senator Whitehouse, is all over them. Yes, second Senator Whitehouse, he's amazing. I think the case that Robin is talking about it's the Voting Rights Act case. It was Allen versus Milligan, which was talking about gerrymandered maps that were politically gerrymandered and also racial. So, do I think Roberts convinced Brett Kavanaugh, to side with him to soften the blow? I do think the reason they released that case earlier was to get a good news cycle. They put that case out about 3 weeks before the end of term. I talked about this with my patrons. The problem with the Voting Rights Act case is that one of Roberts's lifelong career goals has been to destroy the Voting Rights Act. And he did 2 just huge body blows to the Civil Rights Act. First in 2013 in the Shelby County v. Holder case, and then again in 2021 in the Brnovich case. There are some other cases too that have really not just chipped away at the Voting Rights Act, but left it all but hanging by a thread. I think Roberts wants to cut that final thread. I think he will cut that final thread at some point. But it goes back to what I was talking about earlier with him being this brilliant politician. Like, he knows that he has to slowly boil the frog, that we can only take so much. And like, as wrong as I think the affirmative action case was, like the numbers publicly on that are not where they should be. It was politically, it's not going to do that much or as much damage to the court as a lot of people think it probably is. So he is trying to slowly boil that frog, and he'll save it for another day. He knows for sure that there's no shortage of cases brought under the Voting Rights Act that are going to, and more were going to come his way, and he can afford to play the long game.
Yep. $10 from Housemaster Poding. Thank you for all you guys do on the line. This is truly a service to the people. Thank you so much. I appreciate that greatly.
$9.99 from Evelyn Wu. Thank you, Mr. Seidel. I loved both of your books multiple times, and you are my inspiration for starting law school. Oh, wow. Thank you so much. I hope to follow a similar path and do everything I can to make a difference. Evelyn, I'm thrilled to hear that. Please reach out to me. Hit me up on one of the socials or through my website, and we will chat more. Thank you.
And let me tell you, I don't know Andrew as well as I would like to. I wish we lived closer and time so we could just be normal friends and hang out and do other stuff. But when he says contact him, he's serious, because I've already directed one of my other friends to him for help and advice, and they are working towards a law degree there as well. And so, yeah, we need more. We need people to talk to their legislators and do everything we can to support that. But we also need people becoming legal experts, lawyers. I hate saying it, but that's the legal expert, in order to fight this stuff and help unfuck the courts. Because I think I'll just say it, because there's no trouble I can really get in. The lawyer representing Colorado fucked up, in my opinion. I have no legal grounds to say that because I'm not a lawyer, but I'm genuinely baffled as to how this thing could have gone through the various processes. And then we find out, oh, wait, even the one client that was listed wasn't even real. And we stipulated to a number of things and just let Kavanaugh let Gorsuch take the low hanging fruit. I think the lawyer fucked up, but I don't know enough. $9.99 from Wesley Commons. As a Christian pastor, I appreciate what you're doing. Theocracy is a nightmare and is terrible for churches too. Christians have no right or mandate from Jesus to legislate morality. And see, here's a Christian that I can work with on the church-state separation stuff, just like I could with the Reverend Barry Lynn, and then debate him all day on whether or not there's a God.
Yeah. Amen, Wesley.
All right.
$10 from Sam Mayer. Andrew Seidel, I love the founding myth, but it's true that some founders thought they were founding a Christian nation. They were moderated by others, deists. It's the absurdity of original public meaning. There is no one. Yeah, I mean, I do talk about that quite extensively in the founding myth, that when we say the founders, you have to take that with a grain of salt, because the founders were not a monolithic block by any stretch of the imagination. You've read the founding myth, Sam, you know. So I'll leave it there.
Cool. $10 from Zick Hughes. Thank you very much. What do you think is worse, today's evangelicals or the colony's Puritans? The Puritans, by the way, repealed the Maryland Toleration Act, Trinitarians twice. That act could put Trinity violators to death. I think it's worse now. Just because the stakes are higher.
Yeah, I'm gonna say modern Christian nationalists too, because the difference, right? Like the Puritans and the Pilgrims and that all happened before there was a separation of church and state, before there was a U.S. Constitution, before they knew better,
before there were 100,000 people in the U.S.
150 years before is when they started coming over, right? Like, so that to me is, look, we were not founded as a Christian nation. We're better for it. We were the first secular nation, the first nation to separate church and state, the first whose constitution did not invoke a deity, the first to ban religious tests for public office, right? All of those are things that we actually can and should be proud of, to the extent that you can be proud of anything that you didn't contribute to as Americans, right? Like those are the things that could make our country great. Those are the things that I think we could take pride in. We certainly should not be burying them under myths of a Christian nation. But the point being, like, that is what those were some truly unique and original contributions that America made to political science and to humanity. And modern Christian nationalists are actively trying to bury those and turn their back on them, whereas the Puritans did not conceive of them.
Yeah.
$20 from J.R. Ward. Andrew, thanks so much for coming on. Do you think after the court's ruling, the road is paved for people to deny theists service in a place of business, given the Bible was banned similarly in Utah after book banning? Yeah, so there are a lot of things, and I would encourage, if you have not read American Crusade, I would encourage you to. I don't think this strategy would work out well. I mean, I would expect it to happen after this case at least once or twice. I believe in the Utah banning the Bible decision that was walked back, actually, and that the Bible is now back in that school. One of the problems we haven't talked about with the denial of service is that it's not just a business by business decision. For instance, all across huge swaths of the country, before we had Civil Rights Act, the KKK actively pressured businesses not to serve blacks, to remain segregated, even if they wanted to, right? Like, as a business, the rational thing to do from a market would be to serve anybody who has money, right? That's what you would do. That would make you the most profit. But the marketplace is not rational for a whole host of reasons, not the least of which is that every actor in it is a human being. And there are a lot of external pressures that can be put to bear on businesses. I mean, you can imagine a small town somewhere in the South where one business announces that it's not going to serve LGBTQ people because it's against their freedom of speech. And then the majority of the town is in favor of that, and it starts asking other businesses why they're serving LGBTQ people and saying, well, if you're going to serve LGBTQ people, we as the majority are not going to come visit you. We're not going to come to your establishment, right? Like there is going to be pressure put on other businesses to go along with these things if history is any guide. And if you want to read more about that, there's some really terrible U.S. history that I touch on briefly in American Crusade.
And this may be the last super chat, unless somebody gets another one in while we're reading this and summarizing. But $10 from David Stekety. Thank you so much. And sorry for butchering your name one of those two times, if not both. Is the manipulation of the courts and the sourcing of cases a relatively recent phenomenon? When I studied constitutional law, the cases of consequence seem to arise more genuinely.
Yes, I believe it's a relatively recent phenomenon. I have a law review in the back of my mind working on this. I think you could really date it to after the 1990s when a lot of these Christian nationalist groups sprung up. Groups like ADF, First Liberty Institute, all that started springing up with the express purpose of ticking off the goals on the conservative legal movement. Also, shout out to David Stekety, who was a plaintiff in a case that I litigated against the state of New Jersey, which stopped the flow of public funds to churches. David and I won a unanimous decision from the New Jersey Supreme Court back when I was litigating cases at the Freedom from Religion Foundation.
Wow. Yeah, I don't have shit like that on my resume. I love the fact that I at least know and respect and admire somebody and can call somebody a friend who does. Thank you for all you do and for reaching out to me and being willing to come on here. I know that there's a lot going on. So question number one.
Yeah.
What does every single person watching this need to do?
I know everybody's scared right now. I know a lot of you are probably terrified for very good reason. And as trite as this sounds, I don't think this is not the time where we give up. Hold on to that hope. I still have a lot of hope. I mentioned that the reason we are seeing white Christian nationalism raging against the dying of their privilege, I mentioned that the reason why is that we are winning on the demographic side of this. Their ideas are wildly unpopular. They're trying to legislate from this minority position of power on the Supreme Court. So don't give up hope. I think that is absolutely key. I would encourage everybody to go join the organizations that they feel like align with their values the most. You have got to get involved in this fight in more ways than just talking about it on social media. That's not enough. Join Americans United for Separation of Church and State at au.org. I really also encourage people to go arm themselves with the knowledge that they need. I don't care if you buy my books. I'd be more than happy for you to go borrow them from your public library. The number one thing I think that we really need to do is focus on correcting and expanding the court. And that means talking about it and putting pressure on politicians to do it. I firmly believe that is the policy solution the only policy solution that matters. Until that's done, everything else is in jeopardy.
That is a good enough piece of advice and a little bit of positivity in what has been just, a kick to the nuts for years now. That just, it's like watching a gag reel of it happening over and over and over again, or to whatever soft dangly bits someone else might be getting kicked in. For me, that's the case. Huge thank you to Andrew Seidel for coming on here. We'll get him back as soon as we possibly can. And anytime there's any new information, if you have an interest, go to andrewlseidel.com. You can find his books and other things. Also, you can go to au.org. There are plenty of organizations for you to get involved with, not just Americans United, but Freedom from Religion Foundation and many others that are working towards church-state separation, including I'm on the board of directors for American Atheist. We have our own legal team as well. Some awesome people there that I get to hang out with from time to time. And these organizations frequently work together in some way or another, perhaps with a writ or in communication behind the scenes. The world is a fucking mess right now, but it's not time to give up. It's not time to push a hard reboot, nuke it from orbit. Why don't you put her in charge? It's time for everybody who's been sitting back saying, oh, voting doesn't matter, to realize you were wrong. It's time for the people sitting back saying, oh, both parties are the same, to realize you were wrong. If both parties were the same, there wouldn't be a fight for power. There wouldn't be contests. There wouldn't be people trying to claim that the election was stolen. There wouldn't be people saying that Trump's impeachments were politically motivated and dishonest, or there wouldn't be people going after Hunter Biden all the time or talking about how cocaine was found in the White House, as if I give a rat's ass that, or I'm at all surprised that cocaine was found in a building where a bunch of people work and where there are tours of visitors at a period of time when the president wasn't even there. But I'll tell you this, somebody can beat me up for it all they want. If Joe Biden himself was doing coke off the Resolute desk and it didn't impede his job enough to get the shit done, I don't care. That's not the outrage that Marjorie Taylor Greene and others think it is. What is outrageous is scandals in the Supreme Court and now taking fictional cases in order for judicial activism from the bench. I'm not giving up. Andrew's not giving up. The organizations that we work with are not giving up, and you guys shouldn't give up. Thank you so much for your support and your contributions today. Mostly, though, thank you for watching. Share this information with other people and go out and help the rest of us try to unfuck the courts, unfuck the United States, and unfuck our world. We'll see you next week. Hey, look, it's the new credits.
Are you going to
And
put
they
that
can
on
still
a
hear
shirt?
me.
There it is.
Yeah, you guys didn't donate enough.